Well, hello there. Thanks for joining me. I am Dr. Jen, and this is my life as a landlord. I'm so pleased that you've joined me for today's show. Today, we're exploring the location-specific tenancy guidelines for Colorado. Now, if you are a longtime listener of the show, you might know that all of my location-specific episodes have included all kinds of hyperlinks and resources in the show notes for that specific location. In this case, it's all about Colorado. So what we're going to do today, each of my location specific podcasts is set up in the exact same way, answering the same four questions. One, what are the basics of this location? Two, what are the nuances of this location? Three, what about guidance regarding abandoned items, personal property left behind by a tenant? And four, what about help in the general area in Colorado? And then at the very end of the episode, I'll go through what I call my bingo card, which is my list of the most standard items I see when I do these location specific episodes. And as we get more in the library, I actually have a longer bingo card, which is pretty funny. Now, I must tell you that there are very likely more documents, more resources than what I'm going to show you here. This is designed just to get you started. This is not designed for anything other than the state of Colorado. If you've got to do your own research for your municipality, your geographic area, your county, your area of where your rentals are, not where you are, but where your rentals are. So this is very important because you've got to do your own research and you've got to keep current. Even if I got this episode 100% right as of the recording, 5 minutes after I stop recording, the law could change. So you've got to keep up with this. But this is designed to get you started. This is going to give you a running start. Okay, I'm going to give you a shout out today for the sponsor. Our sponsor today is Aloha Capital Investments LLC. If you want to know more about real estate investing or what Mike and I are up to and how you can contribute, check out alohajv.com. Okay, we got all the intro stuff out of the way. I'm going to share screen. So if you're watching on YouTube at My Life as a Landlord, that is going to be best because I'm going to go through each one of the hyperlinks that I've got in the show notes. And if we find some different ones that are better as we go through the recording, I'll add them as we go. And actually, sometimes I'll even take some out. Okay, so we start with basic Colorado public law. Like I've lost my ears. Hang on just a sec. That's okay. So basic Colorado public law, tenant and landlord. This is Title 38, and it looks like Article 12. Now remember, a tenancy law in general is still a law. So this is going to be set up very legalese. It's going to be very technical, and you can see even here, there's two columns and each one is to a hyperlink. So let's go to definitions. Definitions, and it looks like there's many definitions on this side. This is actually really set up very nice. Late fee is defined, monetary sum that a landlord charges a tenant or homeowner as a result of the tenant's or homeowner's failure to pay timely rent that is determined pursuant to a rental agreement between the landlord and tenant or homeowner. Interesting. Okay. Normal wear and tear means the deterioration that occurs based on the use for which a rental or mobile home space as defined by another section is intended without negligence, carelessness, accident, or the abuse of premises or equipment by or chattels by the tenant or homeowner or member of the tenant or homeowner's household or their invitees or guests. Okay. Rent, subsidy, provider note, security deposit. Okay. Security deposit means any advance or deposit of money, regardless of its denomination, the primary function of which is to secure the performance of the rental agreement for a residential premises or any part of the premises. So that is that section's definitions. Okay, so there's looks like there's definitions all over. Let's go to this. This is a different section definition. Okay, so this is defining appliance and common areas, dwelling unit. Let's see if there's anything interested in these. Vulnerable population means children, individuals with asthma, individuals with disabilities, individuals who are pregnant, or any other group of individuals that has health conditions that could make the individuals more susceptible to environmental contaminants. Okay. I'll go with that. Security deposits, maximum amount on and after August 7th, 2023, landlord shall not require a tenant to submit a security deposit in an amount that exceeds the amount of 2 monthly rent payments under rental agreement. So 2 months rent, 2 times rent. Okay. That's one of the most, the bigger ones I've seen, which is makes sense. But let's talk more about this security deposit. Return of security deposit. Let's see. So there's just a bit of a paragraph here. Landlord shall within 1 month after the termination of a lease or surrender or acceptance of the premises, whichever occurs last. 1 month after termination of the lease, surrender, or acceptance, whichever occurs last, return to the tenant the full security deposit deposited with the landlord by the tenant unless the lease agreement specifies a longer period of time, but not to exceed 60 days. So it's 1 month to 60 days. No security deposit shall be retained to cover normal wear and tear. That's pretty standard. In the event that actual cause exists for retaining any portion of the security deposit, the landlord shall provide the tenant with a written statement listing the exact reasons for the retention of any portion of the security deposit. So written statement, not invoices or paid receipts or anything like that, just a written statement. And when the statement is delivered, it shall be accompanied by the payment of the difference between any sum deposited on the security deposit and the amount retained. The landlord is deemed to have complied with this section by mailing said statement and any payment required to the last known address of the tenant, which could be that unit. Nothing in this section shall preclude the landlord from retaining security deposit for non-payment of rent, abandonment of premises, or non-payment of utility charges, repair work, or cleaning contracted by the tenant. Okay, nothing in this section shall preclude the landlord. Okay, nothing in this section. Okay, I'm not getting the double negatives here. Can they keep it for non-payment of rent or not? So it's basically saying nothing in the section shall stop the landlord from keeping the security deposit. Okay, so it looks like you can pay it, non-payment of rent, abandonment of premises. Okay, interesting. Okay, so then there is late fees charged to tenants and mobile homeowners, maximum late fee amounts, prohibited acts, penalties, secures. Okay, so let's go into late fees because this is on my bingo card for sure. Max late fee amount. Landlords shall not take any of the following actions or direct any agent to take on behalf of the landlord to charge a tenant or homeowner a late fee unless the rent payment is late by at least 7 calendar days. 7 calendar days. Okay, so that's very specific. And charge a tenant or homeowner a late fee that exceeds the greater of either $50 or 5% of the amount of the past due rent. 5% of rent or $50, whichever is greater. The greater of, okay. You have to disclose it in the rental agreement, right? It has to be in the lease that you're going to get that. Remove or exclude. Okay. Just going through some of these. It talks about a mobile home park, which I'm not going to cover. Okay. You can't impose a late fee for more than once each late payment. And you can't pay interest. They don't have to pay interest on the late fee. Okay. Boy, this is a long section. Okay. And then it talks about if the landlord violates that. Okay, so this is still the first hyperlink. So I want to make sure that I'm hitting the high points here. The only other thing I can think of at the moment is, rental application fee limitations. This is on the bingo card as well. This is actually a menu. This is actually really set up well. I don't normally see this actually. The landlord shall not charge a prospective tenant a rental application fee unless the landlord uses the entire amount of the fee to cover the landlord's cost in processing the rental application based on actual expense the landlord incurs in processing the application, or the average expense the landlord incurs per prospective tenant in the course of processing multiple rental applications. Okay. And there's some other conditions as well. But basically, it's got to cover the actual costs. If you're going to do a background check, you're going to do a credit check, you're actually going to process this, or you're paying someone to do that, then the potential tenant is going to pay for that. Okay. So there is that. That's interesting. That's good. Violation, security deposit, homeowner meetings. I'm looking for rent increases. Let's just see if we can find this. Rent increases, new developments. Oh, here we go. Control of rents and count by counties and municipalities prohibited. Legislative declaration. This is really interesting. The General Assembly finds and declares that the imposition of rent control on private residential housing units is a matter of statewide concern. So they're deeming it statewide in Colorado. Therefore, no county or municipality may enact any ordinance or resolution that would control rent on either private residential property or private residential housing unit. And then it talks about some other legalese. But they're basically saying that the municipalities and counties cannot do individual rent control. That's it. Hmm. Okay, well, that's different. I've never seen that. Um, no city or county can rent control. Okay, got it. All right. I'm still looking for rent increases. I'm not seeing it, but that doesn't mean it's not there. Lots about bed bugs. Wow. Lots. Let's look at bed bugs here for a second. Bed bugs, notification to landlord, landlord duty. A tenant shall promptly notify the tenant's landlord via written or electronic notice when the tenant knows or reasonably suspects that the tenant's dwelling contains bed bugs. A tenant who gives landlord electronic notice of a condition shall send such notice only to the email address, telephone number, or electronic portal specified by the landlord in the rental agreement for communications. If this is not available in the absence of such provision in the rental agreement, then the tenant shall communicate with the landlord in a manner that the landlord has previously used to communicate with the tenant. So if you're texting or your, letters, whatever it might be, the tenant shall retain proof of the delivery of electronic notice. Okay, so it's saying not more than 96 hours after receiving notice of the presence of bed bugs or the possible presence of bed bugs, the landlord, after receiving this notice, shall obtain an inspection or dwelling unit by a qualified inspector and may enter the dwelling unit in or any contiguous dwelling unit for the purpose of allowing the reason for inspection. And if the inspection of the dwelling unit confirms the presence of bed bugs, the landlord shall also cause to be performed an inspection of all related dwelling units as promptly as reasonably practical. At least they're being practical. 96 hours in the world that we live in now may not be reality. It may take longer than 96 hours, but if a landlord is trying, if you can show that you're actually trying, that's different. So there's a bunch of notifications about bed bugs in here, so I'm going to leave that. Prohibition on retaliation and harassment. So this is probably talking about landlord retaliation. Management shall not take retaliatory action against a homeowner or resident who exercises any right conferred upon the homeowner by some different locations in this act, except as described in a different subsection. Looks like within 120 days preceding management action, the homeowner or resident complained or expressed intention to complain about a government agency about the matter of this is mobile home park. Okay, submitted the complaint. Basically, they've submitted a complaint in some way or organized a tenants union, or filed a complaint of some kind regarding safety issues in this. It says water quality complaint. So this presumption of retaliatory action described does not in this section does not apply in certain places, certain locations, okay? But the management shall not harass, intimidate, threaten, attempt to harass, intimidate, threaten, or anyone filing or attempting to file a complaint, joint or attempting to join either the complaint or assembling a union or association of residents or homeowners, or coerce or require a person to sign an agreement. Okay, so it does define landlord retaliation. That makes sense. Okay, what's a closed park? It says closed parks prohibited. Neither the owner of a mobile home park or the owner's aid. Okay, so this is all mobile home. I'm not going to go into the mobile home stuff. Entry fees prohibited. I'm not seeing rent increases at all, but we will very likely see this. Oh, here we go. Written rental agreement, notice of rent increase. Let's do this. Notice of rent increase. Notwithstanding any other law in a non-residential tenancy, So non-residential is commercial. Okay. Non-residential tenancy 1 month longer. Okay, where there is no agreement, landlord. Okay, but that's non-residential. We're talking residential. So it's saying notwithstanding any other law, a residential tenancy in which there is no written agreement between the landlord or the tenant, landlord may increase the rent only upon at least 60 days written notice. So if there's no lease in force in Colorado for a dwelling unit, then so it's just an oral handshake agreement, then the landlord may increase the rent with 60 days written notice to the tenant. And let's see if there is, what if there is one? Oh, there isn't. It doesn't say it. Okay, there's more about rent increases though. Limit on frequency of residential rent increases. In residential tenancies, a landlord shall not increase the rent more than one time in any 12-month period consecutive occupancy by the tenant, regardless if there is a written rental agreement or not, the length of tenancy, and whether the rental agreement is either a fixed tenancy or month to month or an indefinite term. Okay, that's pretty standard. Okay, written rental agreement prohibited. Okay, I'm going to do this one and then we're going to go to the next hyperlink because there's a bunch in here. Okay, prohibited clauses copy tenant a copy. Let's see if it's required. Written rental agreement must include a statement indicating that the tenant name and address, the person who is representing the landlord or their agent, and if the identity is if the landlord or the landlord's authorized agent changes, then you've got to provide obviously an updated one. Let's see. Written agreement must not include basically fee shifting clauses where it can be kind of sketchy. Okay. There was a copy required in here. Okay, so then there's more definitions in here as well. Okay, so let's go back up to if there is a written rental agreement, the landlord shall provide the tenant a copy of the agreement that is signed by the landlord and the tenant no later than the seventh day after that. So 7 calendar days seems to be pretty standard in Colorado. Seventh day after the tenant has signed the agreement. A landlord may provide the tenant with an electronic copy of the agreement unless the tenant requests a paper copy, which is fine. I always email everybody right after 7 days. Okay. I'll buy that. And I'm just looking at the rest of these. Okay, so there's a bunch more. Okay, let me go to the next one. Landlord tenant. Now this one is 25 pages long. So I'm not going to go over what we just have gone through because it's quite hodgepodge, right? So this one's talking about what is a lease, what's in a lease, standard lease terms, and there's actually a handbook. I guess is this a handbook? It's calling this a handbook. Okay, so it's as a minimum, the lease should have the amount of rent when it's due, grace period and penalties, if any, for late payment of rent, how long the lease is in effect, i.e. the term of possession, who's responsible for utility payments, who pays for what, who's responsible for minor and major repairs to the rental, especially to the appliances, plumbing, heating, cooling, circumstances where the landlord may enter the unit, length of notice for proper notice, length of notice required to the tenant, hours and days, whether the tenant must be present, emergencies, repairs, showing for sale or rental, etc. Who will be responsible for snow removal, garbage collector, and lawn care? This is really important, especially if you have issues with wildlife and snow. That's really important that you do that in advance. Whether the tenant can sublet or assign the lease during the term. And it doesn't appear that Colorado has, just by this list, I would say that it doesn't appear that they have a standard rent form. There are standard lease form. There are other locations that have standard lease forms that don't necessarily need to list this. They just say use the standard lease. Okay. Joint and severability. Attorney's fees, privacy. If a lease does not include a written clause specifying when the landlord can enter a rental property, a tenant has exclusive use of the property. So this is definitely regarding the abuse of access that some landlords will utilize, which is amazing. There's actually on this page here, I'm on page 2. Tips for landlord. Both a credit check and background check can be helpful when deciding a prospective tenant. Be aware, however, that if you require one prospective tenant to provide the information necessary to perform a background and credit check, you must require the same information for all prospective tenants. And that is true. We have a saying that what you do for one, you have to do for all, and that's true. Criminal background check. There is Colorado Bureau of Investigation, and there are two websites that they give you. So the first one is cbirecordscheck.com and the other one is cocourts.com. And then the credit check, you've got the three credit checking bureaus for the US. For my Canadian counterparts, these are a little bit different. But if you are a Canadian owning Colorado rentals, I think please reach out to me because I'd like to interview you for the show. So, all right, insurance. Let's see. So this actually talks about renter insurance. That's interesting. Uh, that it actually has in here if the state of Colorado near the city nor the city of Longmont require landlord to compensate a tenant for damage to that tenant's personal property. If the lease does not contain a clause requiring the landlord to compensate a tenant for the damage to personal property, the tenant may wish to purchase renter's insurance. Renter's insurance is usually very affordable and may cover not only the damage to the personal property, but theft or other types of property loss, including to the rental unit. So that's actually pretty good. Security deposit, we've already mentioned already, subleases and assignments. We're going to leave it. They have some examples in here that's good. Unenforceable clauses. So this is where the landlord is trying to get the tenant to agree to something that is not allowed. So here's a perfect example. Unenforceable clause requiring a tenant to waive the right to return the security deposit, meaning they're trying to get the tenant to agree that they don't have to give the security deposit back. That's unenforceable. And there's a whole bunch. Term lease, so the types of leases, verbal lease and agreements, which please do not do that. Everything should be in writing. Can lease provisions be changed at any time? They can only be changed if both the landlord and the tenant agree to the change because it is agreement between the two of you. You can't just arbitrarily say, yes, I want to change this. What happens to the lease if a rental property is sold? What happens is a change of ownership. So this is what Colorado says. A landlord cannot terminate a lease simply because the landlord wishes to sell the property unless the lease expressly gives the landlord such a right. If the rental property is sold, the new landlord/owner must honor a rental contract existing at the time of sale. All lease terms, including the termination date and amount of rent, must be honored by the new owner/landlord unless the new owner/landlord and tenant agree to make changes. And the tenant should always continue to pay the rent original landowner until the tenant receives written notice signed by the original landlord and owner directing the tenant to send the rent to someone else. If when a property is sold prior to the end of a lease term, the original owner landlord has two alternatives regarding the tenant's security deposit. You can either transfer the security deposit to the new owner landlord and notify the tenant by mail that this transfer has been made, or return the security deposit to the tenant per the terms of the lease, less any legitimate deductions. Typically, what happens is the security deposit is transferred via escrow to the new landlord, and so it is not normally returned to the tenant. That almost never happens, not that I've ever seen. So it's talking about foreclosure, discrimination protection, and they've got some examples of illegal advertisements and legal advertisements. So let's go through one of these. Apartment for rent. One bedroom, quiet, homogeneous, all-American neighborhood, married couples and empty nesters preferred. That's an illegal advertisement. Legal advertisement is very simple. Apartment for rent, one bedroom on a quiet block. Done. You cannot pigeonhole who you want in your ads like that. You can't do that at all anyway. Okay. It talks a lot about fair housing, federal and Colorado Fair Housing Acts. You want to make sure you're into this. Rental period or tenancy, landlord rights and responsibilities. This is pretty standard. And then it talks about Longmont Property Maintenance Code zoning ordinances. If you have a rental in Longmont, you need to make sure that you are up on what you need to do specifically for that location. And that goes for any location in Colorado. Make sure you are clear on this. Here's something different. Let's go. Oh, this is in Longmont. Occupancy limits. The number of people, this is just in Longmont. The number of people permitted to live in a single unit, single rental unit, house or apartment is determined by the Longmont's municipal code's definition of family. Only one family is allowed to live in a single rental unit. Family is defined as two or more persons related by blood, marriage, adoption, or legal guardianship, including foster children, two unrelated persons and their minor children living together in a dwelling unit, or a group of not more than five people not related by blood, marriage, adoption, or legal guardianship, including foster children living together. So it says the above list do not include all the minimum health, safety, maintenance requirements and zoning ordinances for rentals. So this is really important. If you've got specific units here, you need to make sure you are clear on how to do this. Tenant rights and responsibilities: pay your rent and utilities on time, behave, comply with the terms of the lease, repairs and maintenance, obligation of the landlord to maintain a habitable premises. And a tenant may withhold rent from a landlord if and only if three conditions are met. So this is regarding habitability in Colorado. The tenant finds that the rental unit is unfit for the uses reasonably intended by the landlord and the tenant, and the rental unit contains a condition that is materially dangerous or hazardous to the tenant's life, health, or safety, and the landlord has received written notice on the condition and has failed to correct it. And then it has a bunch of uh, standards. So it says a habitable rental unit must meet the following standards: waterproofing of roof, unbroken windows and doors, plumbing and gas fixtures in good working order. And there's a bunch. I'm not going to read them all. Termination of the lease. We've got, how is the lease terminated? Voluntary termination. Someone gives notice. And termination of month-to-month lease. Early move out. Involuntary termination, meaning an eviction. Landlord may initiate an eviction action to evict the tenant for the following reasons: tenant has failed to pay rent, or tenant has violated a term of the lease, or tenant has committed a substantial violation while in possession of the rental premises, which may include, for example, a violent or drug-related felony on or near the rental property, or an act or near rental property which is substantially endangers a person or the person's landlord property, or tenant refuses to leave the rental after the end of the lease date, which includes month-to-month tenant staying on after the landlord has given required notice. The lease will not be renewed at the end of the month. So just based on those, you can tell that the fixed rental agreements, fixed leases end abruptly. Meaning, so if you're going to renew, then you've got to either give notice that you're going to non-renew, or if you're going to start another fixed lease. It does not automatically convert to a periodic month-to-month tenancy. Talks about illegal evictions. Do not do this. I'm not even going to go into it. Makes me angry to know people do this. It's not good. Tenant violates the lease, or demand for compliance, right of possession, or 3-day notice. So before filing an eviction in court, the landlord must give the tenant notice of the landlord's intent to evict by serving the tenant a demand for compliance or right to possession notice known as a 3-day notice. The 3-day notice states that the tenant must cure or fix the lease violation or vacate the property within 3 days, not including the date of the posting. So it's really 4 days. Weekends and holidays are included, so we're talking about calendar days here. However, if the third day falls on a Sunday, it's a good idea to give the tenant through the next day to pay the rent or cure the violation. Yeah. Okay, so and then there's a bunch of things that must be on the 3-day notice. I'm surprised they don't have like a template for this, and maybe they do, so we'll see. If the tenant pays the rent or fixes the lease violation within the 3-day period, the landlord must accept the money or cure and cannot evict the tenant. But not, it says too, of course, some lease violations cannot be cured, such as the commission of a substantial violation. Yeah, that's no good. Okay, and then it starts to go through on how you can serve. You can start filing up here. Okay, what could happen in court? Oh, typical eviction timetable. This is interesting. So non-payment of rent is on day 0. Landlord serves a tenant with a 3-day notice to pay rent or move out on day 1. Tenant must pay rent owed or move out by day 4. And if the tenant does not pay or move, landlord may file an eviction action at the county court and serve tenant with complaint and summons on day 5. Tenant may file an answer. Tenant has 5 days, but no more than 10 days to file an answer. And the answer must be filed in court by the return date specified in the summons trial date set by court, and then the return date. If the tenant does not file an answer, default judgment is entered in the favor of the landlord. If the judgment for possession is entered, the landlord can have the sheriff assist the tenant from the rental, and if not moved out within 48 hours of the time entered, actual date depends on the appointment made between the landlord and the sheriff. And if the tenant did file an answer, the trial may be scheduled within 5 days of return date. We've actually gone through something like this in the state of Hawaii, and it can be really stressful. It can be really stressful. And the rental we had was literally across the street from us, so we were seeing these people often. It was really kind of weird. Okay. Oh, here's abandoned property. Another bingo item. Okay, here we go. Personal property is considered abandoned if the tenant has not contacted the landlord for at least 30 days and there is nothing to lead the landlord to believe that the tenant is not abandoning the possessions. Okay, that is a very weird sentence. There is nothing to lead the landlord to believe that the tenant is not abandoning the possessions, meaning the landlord believes the tenant is abandoning them and they haven't been contacted within 30 days. And I'm assuming that this is also because the rent has not been paid, but they don't say that. Okay. If a former tenant leaves possessions behind, the landlord should make reasonable effort to contact the tenant. If the landlord is not able to contact the tenant, the landlord may proceed to sell or dispose of the personal property. However, by law, the landlord must give the tenant at least 15 days written notice by registered or certified mail addressed to the tenant's last known address, which could be the rental unit, before selling or disposing of the property. If the last known address is the landlord's rental property, send notice to that address. If the tenant has not left a forwarding address and the notice is returned, the landlord should retain notice unopened in the file. In a file, should tenant later assert that no notice was given. To reduce further chance of future liability, the landlord could obtain a writ of restitution, and it talks about how to do that. If the abandoned property is a motor vehicle, which is a whole nother can of worms, because the motor vehicle is titled, the procedure to remove it is different. If that is in your situation, it is advisable to seek guidance from a local law enforcement or an attorney. And you can also just straight up call the DMV. That has happened. Yeah. Okay. So security deposit, reasons to withhold a security deposit. It goes through what's normal wear and tear. Not bad. This is actually pretty good. Tenants' recourse for withheld security deposits. And the tenant may sue the landlord for 3 times the amount of their deposit. That's a lot, I think that's pretty standard. That's what it is in Hawaii. 3 times the safety deposit if not returned. They have to demand it, and then you basically have to go to court. Typical, it's small claims or something similar. This is talking about roommates now. I'm on page 22. Roommates, forming a contract between roommates, procedure when one roommate moves out. This is good. So I actually like this. This is roommates and how to do roommates. That's actually really good. I'm shocked. This is actually 3 pages long about roommating with each other. And okay, when someone moves out, and then the biggest thing is when roommates move out, what about the deposit? That's what everybody always says, right? Okay, so subletting and assignment agreements, and then mediation. Cool. Okay, so that's the second hyperlink. Goodness sakes, that's a long time. That's okay. So the next one, Colorado Law Summary, Renters' Rights. This is 9 pages. And we're just going to hit the few things that we know that we have not gone through yet, which just going to look real quick. We've actually done pretty good. Non-payment of rent. So you can withhold the security deposit for non-payment of rent. Got it. An abandonment of premises because you've got to deal with everything inside there. Security deposit amount can't be more than 2 months. And any additional pet security deposit must be refundable. Okay, so that's the first time I've seen a pet deposit at all. So pet deposit, is indeed a deposit. Okay, so let me read this because now it's got some pet stuff in it. Okay. A landlord cannot require a tenant to submit a security deposit in an amount that is more than 2 monthly rent payments under the rental agreement. If a prospective or current tenant has a pet, a landlord is prohibited from demanding or receiving an additional pet security deposit from the prospective or current tenant in an amount that exceeds $300. Any additional pet security deposit must be refundable. Okay, so the pet deposit. So if you've got pets, I wonder if it's per pet. Hmm. Okay. So if you've got, I hope you have some bucks, Colorado folks, because 2 times the rent amount plus if you've got 2 dogs or 2 cats, something plus $600, that's which maybe I have that wrong, but still $300. That's not zero. Um, okay. Tenant's legal recourse. We're going to keep going. What happens to security deposit if there's a new landlord? We've gone through that. Warrant of habitability, uninhabitation, landlord must remedy or repair an uninhabitable condition. We got it. We've got tenant remedy, landlord defense, prohibition on retaliation. Yeah, landlords cannot retaliate against a tenant by increasing rent, decreasing services, or terminating or not renewing. Um, and it is within 120 days. Oh, there's even more. Bringing or threatening to bring. Okay, we did talk about this. So 120 days. Um, it would look like the landlord is retaliating. Well, the last one said 120 days. This one doesn't, though. Okay. But at least it's in there. Landlord is, yeah. It doesn't, the last one says 120 days for retaliation. Okay, termination and eviction, and then conclusion. Okay, so that's the other one. I'm not going to go back into this one. Let's go to the fourth one. So this one I got Colorado Department of Regulatory Agencies, and this is the Division of Real Estate. And what they've done is they've created a leases and renting basics, and it's frequently asked questions on leases and renting. Now, these are all hyperlinks, and there is a video, and there's actually a couple other videos too that look pretty good. And so this is pretty basic. Like this isn't like super technical. So I'm just going to leave this there because I think we've got most of what we are talking about here. We're going to jump back into Colorado public law because this is talking about abandoned property specifically. Um, yeah, so we've talked a little bit about this already. Typically with abandoned property, there is some kind of a period where you have to actually verify that the unit is abandoned, right? And so in this case in Colorado, it's 30 days. But then there has to be like a waiting period because you kind of have to wait or see if the tenant's going to come back to get their stuff. So there's a second period, which in this case in Colorado is 15 days. And then the whole time you're supposed to be trying to get a hold of your tenant. Well, if they're in the hospital or they're in jail, you can get a hold of the tenant all you want, but unless they're willing to do something or try to get family to help them or something, then the unit is going to go abandoned. And then you've got to let them know, so you've got to give the notice, the certified mail, registered return receipt. And it does talk again about abandoned motor vehicle, which is a whole different animal. We're not talking about that one. And it talks about how to do the vehicle, like a lot about the vehicle. Okay, we're going to leave that one there. So that the looks like the fifth hyperlink was all about Colorado public law about abandoned property. So I'm going to leave that. And then this one is about storing the abandoned tenant property in Colorado rentals. So this is a comprehensive guide to storing. So this is from December of 2024 and it looks like it's from a legal, like a law firm. So I included this. This might be helpful, and it does have some hyperlinks in it. But it's talking about abandoned tenant property is personal belongings left behind by a tenant who's vacated the rental property, often without notifying the landlord. In Colorado, the determination of what constitutes abandoned property is governed by specific legal standards set forth within state law, which we've already established. And this looks pretty generic, actually. Personal property, 15 consecutive days. You've got to actually let them know. Yeah, they have not made any rental payments for 15 days. assessing the abandonment. Oh, I like that. Assessing the assessing timeline and then the storing timeline. Okay, 14 days. 14 days from the date of mailing to reclaim their belongings, and it's on the 15th day that people can start disposing. So safe storage methods for an abandoned property. Because remember, if you have got a unit that there's items that's been abandoned in it, the one thing they're not, obviously they're not paying rent. And so the one thing that you want to do is you want to get in there, clear that unit out, freshen that unit up, either cleaning, renovation, whatever is applies. If there's damage in there, obviously you got to repair it. But you're trying to get it back on the market as quick as possible, start looking for another qualified tenant, right? And so then of course as a sideline you've got to deal with this abandoned property. So days count in this. You want to make sure you're really keeping notes on what days you're doing what. It's very important. And best practices for managing abandoned property in Colorado. Okay, so this is just an extra little article for you if that will help. And then this one I had Googled Colorado legal aid. And so the Colorado Poverty Law Project jumped up, and there's some different options in here. But as far as helping, there is numbers on the bottom of every one of these pages, right? So I even go to the Colorado law one, about us, contact us. And absolutely, just, call them up, Colorado Bar Association, find a licensed lawyer. In fact, I'll put this one in the show notes right now. I put in fact, I'm going to take the Poverty Law Project out because I'm not sure that's going to be super helpful to the landlords who are listening. Committed to public service. Yeah, so at least you'll have some idea about what to do as far as getting more help. And you can also subscribe to their website updates. And there's all kinds of resources in the second hyperlink. There is all kinds of resources based on, I think this is Longmont, but there's a lot of details in this. And even if you call Longmont and say my rental is in Boulder, it doesn't matter because they will help you, right? They will at least give you an idea of what you need to do. And then there's more help. Oh, they don't have any. This is more legal. Okay, Department of Regulatory Agencies. Worst case scenario, if you need help, you can call them. And there's a bunch. Colorado Division of Real Estate, for sure they can help you there. Their number 303-894-2166. Or you can shoot them an email. They've got an email addresses here as well. And you can even schedule an in-person appointment right on their website. This is amazing. And you can talk to them. That's pretty cool. So, and they've got a bunch of other ones here. Colorado Legal Services, Colorado Bar Association, which I've already put in. Actually, Colorado Legal Services. Let me put that one in here. Yeah, I'll put that one in there too. That's good. Okay, so that gets you going. I'm going to stop sharing and then I'm going to go through the bingo card and see what we missed, which we might have missed a few things, but I think overall Colorado did pretty good. I'm actually really impressed. Okay, tenant application fee. Here's my bingo card. Tenant application fee. It did talk about tenant application fee. You can have a tenant application fee, but what you charge one, you must charge them all, and it has to be actual expenses. Grace period for late rent without a penalty. It did not talk about the actual, oh no, it did, 7 days. You have 7 calendar days to pay rent. And then the late fee can be the larger of either 5% of the rent or $50, whichever is easier, whichever is bigger, that's the late fee. Security deposit method is by payment, and it's 2 times the rent. But if you have a pet, there's an additional $300, and I'm not clear if that's per pet or not. But it's also got to be, if you're going to charge beyond that, it's got to be refundable. So yeah, so 2 times plus pet deposit on top of that. That's a lot for a deposit. Plus then you got to pay rent, right? So hopefully you got a chunk of cash. Lease wording and details. Yes, there is quite a list of what needs to be in the lease wording and details. Is there an emergency contact required in the event of tenant abandonment, incapacitation, death, or imprisonment? Nope, there is not an emergency contact required. This is best practice. So if you're listening to this, Please make sure you do this in either your tenant application or at your lease signing. Pets and animals, pet deposit or pet rent. Yes, pet deposit we talked about. There was nothing about pet rent, and there was nothing about pet screening, none of that. Delivery of signed lease is required. Condition inspection at move-in, not mentioned, but also a good practice, especially if you're doing security deposit. A condition inspection at the move-in implies that you're going to do a condition inspection at the move-out, and if you're going to do rent deductions, you have to have both. Now, make sure that if you're going to do a condition inspection, that you do it in writing. Pictures are good, pictures are helpful, but you can't just do pictures most of the time. In most jurisdictions, you've got to also have everything in writing. So make sure you're doing both. So condition inspection at move-in, not mentioned, but it's a good idea. Standard warning letters or wording, didn't see any forms or anything, so no. Required maintenance inspections, no. How often can the rent be increased? Once per 12-month period. What is proper notice on a rent increase? I don't think we dove that far. I could take a guess, but it's in there. I don't know. How much can the rent increase? It did not say. And further, there is no rent control for the city, municipalities, or the counties. It is a statewide controlled thing. And so actually, is there a rent increase in Colorado? I'm going to go back in here. Rent increase amount in Colorado. Done. Let's see what comes up. Notice period. So it's saying there's no statewide cap on the frequency. Okay, wait a minute. Landlords can raise the rent once per year, and there is no statewide cap on the amount of the rent increase. It says or frequency. However, that's not true because you can only raise it once a year. So it says it's no cap on frequency, which is wrong. Key points regarding rent increases. Notice period. Landlords must provide at least 60 days notice before increasing rent for month-to-month leases and 30 days notice for increases of less than 10%. Wow, less than 10%? You can jump it up that high? So 60 days notice. Legal compliance. Yeah, okay. So that's what I wanted to know was how much can they jump it up? So there's no limit. A landlord can do it as long as there's proper notice. Renter's insurance. It did talk about renter's insurance. And one of the resources I've got, it did talk about it. And it did talk that landlords are not responsible. So tenants, it's a good idea. Is abusive access defined? Yes. Is landlord retaliation defined? Yes. Is the end of a fixed lease abrupt? Yes. It does not automatically convert to a periodic lease. Condition inspection at move out? No. But again, how are you going to justify the move in, move out difference? Outside of normal wear and tear if you're going to deduct from the security deposit. Return of deposit or bond timing. I think we did talk about that. Return of security deposit in Colorado. 1 month. That's right. 1 month and within 60 days have to give the itemized statement. That's right. We did talk about statement. Okay. Can you use the deposit as last month's rent? Yes or no? Yes, you can, along with abandonment or any of the other fees that are outstanding, including utilities. How long can you give notice of eviction due to non-payment of rent? 3 days. That's pretty quick, by the way. 3 days. 3 days, non-payment of rent. How long can you give notice of eviction due to mischief? You can still do 3 days. 3 days. Yeah. And then abandoned items, value of items, administrative inventory. So there was a bunch of on the timing of the abandoned items, but they didn't talk about the value or anything like that. So yeah. Okay. We're going to wind it back up here for the state of Colorado. Each of my location-specific podcasts are set up in the exact same way, answering the same 4 questions. What are the basics of that location? What are the nuances of that location? Some guidance about abandoned items left behind by a tenant and where to get help in your local area, in this case, Colorado. Then I went through my bingo card of standard items, which Colorado did pretty darn good. They got almost all of them. These standard items are what I see most often in tenancy laws in these different locations, and I look at this a lot because of this podcast. This is the same format for every location-specific episode, so if you're interested in another geographic area and you want to listen to that one, you already know the format. You're just going to change the area. All good. One more time, the episode is not all inclusive. You must research further in your specific area, including your county, regional district, parish, city, or any other governing body that involves your rental location. Even if I got it 100% right as of the date of recording, 5 minutes after we finish, it could change. So at least today's episode will get you started, and that's the whole idea. So if you're listening to this podcast, chances are you're either new to real estate or you're new to real estate in Colorado. Things you can do to help yourself are familiarize yourself with all of the local resources, not just the ones I gave you, but in your local area. And the second thing you can do is get in the conversation with other Colorado landlords. You can either do that physically in person at meetups or chamber commerce meetings, Rotary meetings, whatever. Physically have conversations with people, or you can do it on social media. There's plenty of places on like Facebook where landlords will meet. There may even be a Facebook landlord group for Colorado. So, but get in the room and ask the questions and see how the other Colorado landlords are responding. They can help you. I hope you enjoyed today's show all about Colorado. Don't forget to subscribe for more expert advice and real life stories from across the rental property world. My Life as a Landlord is getting recorded today from Maui, Hawaii, where we just lost power due to a tree down in across the road. Why? Why does this matter? Because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 198 about the Yukon Territory. I'll see you there.